Well, hello, everybody. Yes, another edition of Zoom Landlord Tenant Talk Radio coming at you every Saturday at 3 p.m. But as you might know, for me, this is a labor of love, kids, because I am floating in the Mediterranean on the Regent Seven Seas Grandeur. And we are going to be docking tomorrow morning at Catacolone, Greece. So right now it is 1 a.m. for me. So if you see me nodding off during this broadcast, then at least you'll understand. I've had a great trip on this. We've learned so much about these countries, and we've also learned these special words. I know I know one word specifically that I've learned on this trip with these foreign words, and I'll just spell it to you. It's Chanel. I've become an expert in that word, ladies and gentlemen. By the way, for noting sake, the name of the song was, since we're in Greece and Italy, was ABBA, and the name of the song, of course, was Mamma Mia. Before we start, I did want to talk about an upcoming event. The Apartment Owners Association is having a big trade show on August 22nd. That will be at the Long Beach Convention Center. It starts at 7:30 in the morning for the first seminar, and then the show opens up at about 8:30. There'll be a bunch of vendors there. You'll get to learn how to operate your buildings more efficiently. You'll learn a lot about the law and literally how to just take care of your property. I, of course, will be speaking at 1:15. Please do not miss my seminar, which will really talk about the laws that you really need to know and how to basically stay out of problems. And so again, put that on your calendar. I will be talking about that next week, but it is August 22nd at the Long Beach Convention Center, sponsored by the wonderful Apartment Owners Association. The opening topic today will center around something that's going to be on our ballot in November, and that's Proposition 33. Proposition 33, the so-called justice for renters. Justice for renters, that's going to be on your ballot. Now, does anybody really believe in the state of California that tenants need more protection? Even the tenants will tell you that the laws are so one-sided in favor of landlords that literally, do we really need a justice for renters? I think what we need is a justice for landlords. But I did want to talk about what this proposition will do. And as the title I posted deals with the only law that is in favor of landlords in the state of California. That law came into effect in 1995. That law was called the Costa-Hawkins Rental Housing Act. That was the only law that ever had it in favor of income property owners, allowing us basically to do our job unfeathered like every other industry is allowed to do, but somehow landlords are in a situation where we're not equal to any other industry. So what does the Costa-Hawkins law do, and how is it affected by this Proposition 33, the justice for renters? Well, first of all, if this proposition passes, ladies and gentlemen, it will revoke all the provisions of the Costa-Hawkins Rental Housing Act. So what does that act do right now? Well, number one, it guarantees that there will be no rent control for single-family residences, townhomes, or condominiums. I don't care when the property was built. I don't care whether a corporation owns it. It makes no difference under the Costa-Hawkins law, which specifically states that notwithstanding any other law, and that's the way the law starts, so I like that part, there shall be no rent limitations on single-family residences, townhomes, or condominiums. In addition, it also states that if you have a property with a certificate of occupancy issued after 1995, that again, there is guaranteed that you cannot be subject to any rent control by any jurisdiction. I don't care whether you're in Berkeley or Santa Monica or West Hollywood or Los Angeles. you have the right, if your property was built after 1995, or if it's a condominium, townhouse, or single family residence. Lastly, what Costa-Hawkins does is that guarantees vacancy decontrol. And if you're not familiar what that actually means, it means that if you have a tenant who's vacated your property, maybe they've been there for 20 years and finally they left and you were subject to rent control for that jurisdiction, the Costa-Hawkins guarantees you that you can raise the rent to whatever you like based on a vacancy. I mean, it seems very reasonable. You've waited all this time. Well, Costa-Hawkins guaranteed that a municipality would not be able to impose limitations when you have a vacancy as to what you could charge. Santa Monica, that wonderful city, did try to impose that, but of course they got struck down by the provisions of Costa-Hawkins, which again has been in existence since 1995. Also, one more thing, which is very important, that the Costa-Hawkins Rental Housing Act did, was that it stated that you can establish any rent on any occupant if all of the original occupants have vacated. So what I mean by that is, if you had a tenant, two tenants that you rented to, we'll call them A and B, and then thereafter C moved into the unit, and you started taking rent from A and B and C, you just didn't think about it, and then A and B moved out. Well, even if you continue to take rent from C, you have the right under the Costa-Hawkins Rental Housing Act to raise the rent to market value, even if you've been taking rent from C. So you might want to think about your situations in your buildings right now. If you do have that situation, you would be able to raise the rent to market level. So these are all the things that the Costa-Hawkins Rental Housing Act established. So what is this Proposition 33, the so-called justice for renters? Well, this is the third attempt by a guy by the name of Mitch Weinstein. He's the founder of the AIDS Society, and he's had to try to pass this. This is now the third time. He's failed the first two times, and now he's trying to do it for a third time. We have to make sure, ladies and gentlemen, that we get everybody out to vote against Proposition 33. That's a no vote for Proposition 33. Bring all your family members, bring your friends, bring your relatives. If you have a Great Dane, dress it up as a human and have it vote too, because we've got to knock this down. This will tremendously impact our property if, in fact, Proposition 33 does pass. We must defeat this. Now, the same thing, which is very interesting, is that Mitch Weinstein, the founder of the AIDS Society, makes profit by selling drugs. And those profits are tax-free based on his status as a nonprofit organization. But you would think that if you're making profits, that those profits would be, since you're nonprofit, would be to find other cures for AIDS or to assist people who have AIDS. But that's not what he's doing. He's using this money, tax-free money, so that he can defeat landlord's position with regard to the Costa-Hawkins Act. So why the crossover, and why using this money, which he got tax-free, to then try to usurp the power of landlords and not allowing them to do their own business. So there is another proposition right next to it. It's called Proposition 34. And this proposition says that if you're a healthcare provider, you will lose your tax-exempt status unless 98% of the revenue that you make is spent on direct patient care. And that makes a lot of sense. You're getting money tax-free. You're supposed to be this healthcare provider. So you would think that the money that you make would go to direct patient care. And this act, this proposition states, Proposition 34 says you're going to lose your tax-free exemption. So of course it was sponsored by the Apartment Association of Greater Los Angeles, and it is on the ballot. And what this will be, it will be cutting the legs off of Mitch Weinstein, because his organization, which is supposed to be used for health care and health decisions for people with AIDS, is using this for other purposes. So if Proposition 34 passes, if he continues in his evil ways to assault landlords, he will lose his tax-free status. So again, let's recap. You're going to vote no on Proposition 33. You're going to vote yes on Proposition 34. And don't forget, you're going to hear me August 22nd at the Long Beach Convention Center, but I will talk about it next week, Saturday at 3 p.m. But of course, by then, I'll already be home. That notwithstanding, we're going to open it up for questions. We're going to start with Anna. Anna, I'm going to ask you to unmute yourself, please. Anna, are you there?
Hi, Dennis. Thank you for staying up and talking to us. I appreciate it.
Well, do I look like I'm awake?
Yes, and I hear you loud and clear. I'm voting no on 33 and yes on 34.
Well, thank you. I am tired, ladies and gentlemen, because normally this old man goes to bed about 8 o'clock. So, but this is a matter of love for you guys. So, what's your question, young lady?
Well, I wanted to make sure I understood you right from, I think, something I heard on a previous broadcast. I do have a tenant that's living in a rent-controlled unit, LARSO. He broke a couple of windows, so I paid to have them fixed, and then I created an invoice and sent him the bill. But he's not paying it. So what can I do in that situation?
It really depends on the terms of your rental agreements. Most rental agreements, and certainly mine and by most of the apartment associations, state that if a tenant intentionally or negligently damages something, then they are responsible for the cost of the repair. So on that basis, he's violating the terms of his rental agreement since he has not paid you for that invoice that you presented him with. So right now, what you would want to do is to serve him with a 3-day notice to perform or quit, giving him 3 days to pay that invoice. And keep your fingers crossed that he doesn't, because if he doesn't, then you have the right to bring forth an unlawful detainer action.
Okay, so on the third day, and he doesn't pay it, if I decide to move forward, what do I do? Contact you and just say he hasn't paid the bill? I need to.
It's so simple, and as I always say on every broadcast, you just got to know this number: 1-800-77-EVICT. Of course, that's my office number. Just give us a call, and we'll be happy to do that case.
Okay, Dennis. Thank you very much.
And thank you, Anna. We're going to move on to an iPhone. I'm going to ask you to unmute yourself.
Hi, Dennis. Thanks for doing this. Quick question. LA City RSO. I bought the property in 2015, and one tenant came with it. He had been there for 45 years, basically born there all his life. He's lived there. His parents passed, so he inherited the property. I noticed that he was getting a bunch of tenants in and out, subleasing essentially. So at some point in 2019, my friend who's an attorney, we drafted a lease. Essentially, he signed it with whoever's already there with all the sublets. There are 3 other people living there. They're going to be the tenants. So he said they're not going to move out. They're not going to move in. I just wanted to bring control, essentially. He pays on time. I have no intention of kicking him out. But my question is, so right now there are 4 tenants on the lease. So if one of them ever decides to move out, which at some point they will, because there's different families, essentially, does he get to choose who to bring in? Because if he's entitled to 4 people on the lease, how does that work? Because if I say no to a new tenant, like who has the power essentially?
Under RSO, you had listed the names of the people who are there. So he doesn't have the right just to bring in anybody. However, under RSO, he does have the right to replace a tenant who's leaving with another tenant. However, he has to first ask you, and you have the right to screen that tenant. And assuming that tenant is a reasonable candidate, then you have to allow him in. But if the person has bad credit, or conversely, if he doesn't ask you and tenant 4 leaves and another replacement comes in, then you would have the right to bring forth an eviction.
Okay, so essentially, if he finds the right tenant, I'd have to let him in. And then the second question, his aunt is paying the rent through Zelle. And on the previous broadcast, you mentioned something about whoever pays the rent, they have some sort of a claim, or it's irrelevant who's paying the rent?
Well, it's not irrelevant, but if they're just paying it by Zelle, then you're not really, quote, taking a check from a stranger and depositing it. It's just coming into your bank account. So I don't see that who's ever actually sending the Zelle payment is creating any tenancy. So I think you're fine.
Okay. Thank you.
Thank you very much. We are going to move on to Scott. Scott, I'm going to ask you to unmute yourself.
Hey, Dennis, thanks for doing this. Two quick questions involving the same thing about process. I'm evicting a tenant and I probably will lose because we didn't file with the LA housing. So we might lose on procedural. If we lose, is it guaranteed that like I'm going to have to pay his attorney fees? That's number one. And then second, what happens next? So he's won the case. He doesn't want to move. Do I sign a new lease? Does he automatically go to pay rent?
Okay, well, first of all, you're saying that you made a procedural mistake. I'm just going to guess that if this was non-payment of rent, that you didn't send a copy of the notice to the city. Is that what you're saying, your procedural mistake?
Correct.
Okay.
Correct.
So number one, would you have to pay his attorney's fees if the matter goes to trial? And if you have a rental agreement signed by the tenant which provides for attorney's fees, then yes, you would be responsible to pay his attorney's fees. Most rental agreements limit attorney's fees to like $500. So unless it says, these are terrible words in a rental agreement, that the victor is entitled to reasonable attorney's fees, you never want to have that in your rental agreement. So, but assuming it's a standard rental agreement by one of the associations or mine, then it's just going to limit it to $500 as your loss. Do you have to have him sign a new rental agreement? No, in fact, he has no obligation to sign a rental agreement. The fact that you lost on a technicality doesn't mean that now all of a sudden magically the rent is forgiven. You'd have the right the following day, as we have done, serve the new 3-day notice, filed it with the city, and start the case all over again.
Okay, great. Thank you so much.
All right, you take care, sir. Okay, we're moving on to, let's move on to Crystal. How are you, Crystal?
Good, how are you?
Can't complain.
That's good. I have a single family residence in the city of Los Angeles. The tenant vacated without giving a 30-day notice. I mailed and placed an abandonment notice on the property and mailed it to the tenant. The tenant responded, and the notice expired on the same day that they responded. My question is,
How did they respond? What did they say?
they responded by sending a letter.
No, but what did they say in the letter? It wasn't a blank letter. What did they say?
Their actual response. Their response was, we told the neighbor and we moved out on the 3rd or whatever. At the end of the day, they never gave.
Okay, so in the letter, they admitted that they had moved out.
Correct.
Okay, so I think from that point when they responded, that's when their liability is extended to. And then I would also count from that point, technically another 30 days from that point, that they're still responsible for the rent. Because if a tenant moves out, they have to give you 30 days notice. They only gave you notice at the end of that quote abandonment period. So I think at that point in time, they're still liable for another 30 days worth of rent.
Okay, so my question to you is related to this security deposit itemization and 21-day rule. What day will that start? Will it start the day that the abandonment notice expired? Will it just start the day that I changed the locks?
Certainly, if you change the locks, it would start from that date, or it would start from the date that they specifically told you, hey, I am out. Once they told you they're out and you got a letter from them which said that, then at that point in time, you got 21 days.
Okay. Yeah, so they gave me a letter on like July the 12th or something like that.
Well, I think you missed your time period if you haven't already done it, but you have 21 days from that date to send them an itemization.
So should I still go ahead and send it in good faith?
Yeah, I would send it immediately if you haven't already sent it. You said July 21st, so there's another 10 days.
No, I said
there.
July 12th. July 12th.
Oh yeah, you're dead. Yeah, you're dead. But you might as well send it now. Okay. All
Okay.
right, thank you very much for your question. We are going to move on to Bobby Alexis. How are you?
Hi, thanks, Dennis. Thanks for taking our questions. So I had a tenant in a property under RSO who started their lease in 2021 with one cat, for which I didn't charge a pet deposit or increase the rent. So in 2023, they added two more cats, and I charged a pet deposit along with a $25 per cat monthly rent increase, which the tenants agreed to. Now, now that they've moved out, the tenant is demanding a refund, citing Civil Code Section 1947.11, and claims that the LA Department of Housing considers charging a pet rent as a rent increase. So my question is, under these circumstances, was I legally allowed to charge the pet rent and deposit in 2023 during the COVID restrictions? And if not, what are my options now that the tenant is asking for a refund?
Good question. And the answer in, your tenant is right and you're wrong. You got to get back the money. You're not allowed. First of all, there is no such thing as a pet deposit. Everything is considered a security deposit. So while, and you could not, at that time, you could only get a 2-month security deposit. So if you raised it an additional security deposit, which you're calling, quote, a pet deposit, you're in violation of the law dealing with security deposits. Also, under the rent stabilization ordinance, you can't charge them extra money because because they had a pet that came in. So I would figure out exactly all the extra money you took during this period, and I would send them a check immediately. Are you still there, sir? I think I lost you. Or maybe you muted yourself. Let me see if I can unmute you. Let's see. Try it again. Bobby, you still there?
Yeah, thank you. Yeah, I muted myself by accident. Okay, thank you.
All right, you take care. Watch your fingers next time, young sir, and give him back the money. All right, we are moving on to Jim Polina. What would it be, a broadcast without our good friend Jim Polina? Say hello, sir.
I am your faithful follower. Okay, Dennis. So, got a question here. I'm in a situation where I am paying the utilities for a tenant. And I put it in this lease that if the water bill goes over X amount of money per month, he pays that excess. Is that enforceable?
I think so, as long as it was in the original rental agreement, because quite frankly, you could have him pay for all the water and all the electricity. So as long as that's in your rental agreement. And you know what, as I think about it, Jim, you always come up with some interesting ideas. We have these tenants, as we know, that just for spite will just leave the water running in the tub 24/7 and build up a bill to $1,000. So if you have a way of saying to everybody in the building, look, this is what the water bill is, to the extent that the bill goes above that, that it's going to be split between all the tenants, or if there's just, let's say, 2 tenants, you in one part of the duplex and the other, that you're going to pay the difference, then at least people will be a little bit of water conservation persons to prevent them from just being maliciously and trying to spend your money. So I like the idea.
Okay, thanks. I do have a second question. I heard the term writ of execution insurance. Have you ever heard of such a thing?
I've never heard of that term, writ of execution insurance. I've heard of writ of execution for possession, which is what
Right.
when we get it to the sheriff, or a writ of execution for money when we're garnishing wages or attaching bank accounts, but not for insurance.
So this is kind of outside your wheelhouse, but renter or landlord's insurance, does it cover lost rent through evictions?
It all depends the terms of your rental agreement. All the terms of your insurance policy. Most insurance policies would not cover that. They do cover lost rent in the case of like a catastrophic situation, like a fire. We had a fire in one of our buildings many years ago, and they took care of the tenants. They also paid us our rent for over a year while the premises were being repaired. But again, that would be part of the terms of your policy.
All right. Thank you, Dennis.
Have a good week, sir. Sonia, are you there? Say hello.
Yes, Dennis.
Hello, Sonia.
Hi, Dennis. My question is yeah, I'm helping my friend out. So it's a unit. It's in Glendale.
Okay,
It's a main house and 3 units. They're all rented. The question is, there is one unit that's the lease is getting ready to expire. I think it's in October, excuse me. So she's debating whether to continue or not. She's been the tenant's been a little wishy-washy by having certain things out or anything, but the main question is if should she renew her lease for another year or convert her to a month to month. We're concerned what will be easier for the landlord if she wants to kick her out because she's violating the lease agreement. She's wondering if the month to month will be safer than keeping her for a whole year under a lease.
okay, first of all, in the city of Glendale, if you have more than 3 or more units, you're under the Glendale rent control ordinance. So there's really little that you can do in terms of saying your lease is over, get out. So I wouldn't have her sign a new lease. I would just have it automatically convert to a month-to-month tenancy, which is what the state law provides for this type of a situation. Now, if she is violating a term of the rental agreement, she doesn't have to wait for the lease to be over. She can start an eviction now, assuming it's whatever that violation is of the substantial nature, which would trigger the ability to then terminate the lease. But the fact that the lease is over doesn't give her the right, based in Glendale, and that you have 3 or more units on one piece of property, that would allow the landlord to say, hey, I'm not renewing, you need to get out.
Oh, really? Okay, so she can't use my requirement is if you don't sign another year lease, you're out. And so that sounds like
Yeah,
that doesn't work.
okay, that is a provision under the Glendale statute that if you have let's say a 1-year lease and now it's approaching the end of that 1-year lease, you could send them a rental agreement and tell them to sign it. Do not accept rent for the 13th month until they sign the new rental agreement. If they refuse to sign the new rental agreement, then technically you could bring forth an eviction. But again, I wouldn't have her sign a new lease. What's the point? If she's violating right now, she's violating a term of the rental agreement, and you haven't really stated what that is, but I would explore that possibility to see if you could evict them.
Okay, thank you.
All right. Thank you very much, Sonia. Let's take a look. We are moving on to, well, I don't know if I can pronounce this, but it seems like to me, Your Majesty. I'm going to ask you to unmute yourself.
Hello, how you doing, sir?
I'm good. How do you pronounce that?
Your Majesty.
Okay, you did good. And how can I help you?
I have a couple of questions for you. I have a tenant that they're Section 8 and they live in the unit in Lancaster. They want to add 2 more people to the lease. I don't want to add the people to the lease. Is it required for me to be able to have to do that?
Just the opposite. If it's under Section 8, Section 8 would have to approve that, and they wouldn't approve that because then that would change the distribution of how much money Section 8 is going to pay versus what the tenant's going to pay. So you certainly don't have to allow additional people, and it would be in violation of the Section 8 contract.
And also, it's a 3-bedroom. It's already 6 people, so 2 more would make 8. I think that would be overcrowding my unit. My house, my home.
Well, I mean, there really is no such a thing as overcrowding under like a state law. I mean, the fair housing has this formula, which is not the law, but 2 per bedroom plus 1. So if it's a 3-bedroom, that would be a total of 7 people could live there. But again, you're not relying on, quote, overcrowding. You're relying on, number one, the terms of the lease, who are allowed to live there, and also your contract with Section 8, which says that these are the only approved people to be there. So you can certainly tell your tenant, I'm sorry, I'm not allowing any other person there. And in addition, if you do bring somebody in, then I'm going to call that Attorney Dennis Block.
Okay, and I have one other question.
Yes, sir.
So we wanted to know that if Section 8 is denying a rent increase. And the tenant has been in the home for 2 years. They keep telling us about the comps in the area. Is the tenant also signed a separate lease agreeing to pay the overage? They've been paying over already. Are they required? Are we able to get the overage from them legally, or are we not able to do that?
First of all, your voice changed, so I'd like to know what happened.
I'm his wife.
Oh, there was a different person. Oh, okay.
Yeah, I'm his wife.
Okay, well, sorry to tell you that what you've done is totally illegal. You're not allowed to take any money in excess of what the Section 8 contract allows. So you really have to be on firm footing here, because quite frankly, they could ask for all that overage back immediately. You're not allowed to do that.
Okay.
So,
Okay.
okay,
Okay,
young
thank
lady
you.
and young sir. We are moving on to P. Harris. P. Harris, say hello.
Hi, Dennis. Pamela here.
Hello, Pamela.
Hi. I love Sally at your office. She is my attorney handling my eviction. We have a tenant who we are in the process of evicting, but they have mold in their unit. So we're
Well,
trying to.
let me stop you here. We do not answer, and I should have made an admonishment at the beginning. We do not answer questions on specific cases. If you do have a case with my firm, you really need to call our firm. And by the way, in case I didn't mention, these broadcasts are for informational purposes only and do not qualify as true legal advice. But that notwithstanding, young lady, if you could just ask me a general question, I'm
Yeah,
happy to
okay.
answer.
So if you have to move a tenant to a hotel,
Mhm.
for a certain amount of time, do you pay the full amount of the hotel cost or just their daily rate of
Okay,
what they're
first
paying?
of all, why do you have to move the tenant to a hotel?
Because of work being done in their apartment.
Okay, so it's work that is required. It's not just like cosmetic stuff.
Correct.
So you might want to take a look at the terms of your rental agreement, especially if you use mine and others. It specifically states that if work has to be done, then you have to have renter's insurance, which will cover the tenant's temporary relocation costs. That's number one. Under general law, you don't have to pay for their hotel or anything. All you have to do is not charge them on a daily rate for the time that they couldn't use the apartment. So if, for example, the rent is, let's just take $1,000 a month, and that would be $33.33 per day.
Okay, and then, okay. So technically their rent, it's $48.65. So we would just deduct that from their
Divide
rent the
by
next
30,
month?
and then that's what their per diem rate is for the dime that they could not use their unit.
I'm sorry, I didn't get the big first of
You
it.
just divide the rent by 30.
Right,
That's the per diem rate, and then however many days that they're out is exactly how much you can tell them, you're not going to have to pay me for 12 days because you were out for 12 days.
okay. And is it 30 days or 31 if they're the month of August?
That's a good question. The civil code talks about every month being 30. So I
Okay.
think that's what we would go on.
Okay, so,
But on that basis, I'd probably give them an extra day, just to be on
Okay.
the safe side. I never liked
Wonderful,
the
thank
civil
you.
code. All right, well, thank you very much. And Diana D, why don't you say hello, young lady?
Hi, Dennis. How are you?
Can't complain.
Good. Hey, Dennis, I have a kind of a two-part question. I gave a substantial rent increase, a 3-month notice, and that rent raise is due in October 1. And I'm finding out that, you know, the property has a commercial zoning, so I actually could get a lot more rent with a commercial client or tenant. And so I thought I would give them, since it's a single family in the city of LA, another 90 days. But I'm kind of concerned that that comes after the election, right? In case that Proposition 33 passes. Is that 33 going to be retroactive, do you think, or?
First of all, Proposition 33 just allows individual municipalities to pass a law if they want to. So
Oh.
it's not going to take effect immediately, because if it's in the city of Los Angeles, then they would have to, city council would have to vote on it, and then it would have to come in. So it's certainly not retroactive. It doesn't immediately put rent control on single-family homes or townhouses or condos, but it does allow municipalities to say, you know what, you can only do a 10% rent increase on a condo, or if your tenant leaves and the place is vacant, I'm going to allow you maybe a 6% rent increase from what they were paying. So we have to really do our best to vote against that.
Right. So is okay, that's really good information. Thank you. So so I have this rent increase, but and these are tenants are like, tenants from hell. And so I'm thinking of doing a substantial rent increase after, but I've already, we're in the midst of this 3-month. I don't want to look like I'm and we're having a problem with repairs and everything. They're playing games with us.
Let me ask you this. Are you going to be using the premises now for commercial purposes only? Are you going to be demolishing it? What are you going to be doing with it once these people go out?
I think just selling it, to tell you the truth. I'm not sure. I mean, if we got a commercial tenant, I mean, there's a guy that has a tree trimming business, and he thought about having, renting the house to some of his workers, and then using the other portion of the property to store his rental his tree trimming equipment. But I don't know. I just would like to. These tenants, they're turning me into code all the time instead of coming to me and saying like my workman didn't make an adequate repair. And so they're just, it's like I can't even keep up with the letters I'm getting from building and safety and code.
But I would write the tenant a letter and tell the tenant that, listen, what you're doing is totally unfair. You're not informing me. You're going straight. So at least you have something on record that the reason why you're getting these code violations is because the tenant's acting like an idiot and not first telling you. You might want to take a look at your rental agreement, because I know in my rental agreement it states that if you go to the city first and I get fined and you never told me, then you're responsible for the fine. I know that's in my rental agreement. I don't think it's in anybody else's, but it certainly is in my rental agreement. So if you use mine, I think you'd be fine. But I would certainly send them a letter to this effect. Also, if you're getting fined, and I think we said this in a previous broadcast, that you go to small claims court, and that's what I would do. So I'm going to sue you in small claims court because I got fined on a regular contractual principle that based on our contractual relationship, the rental agreement, you should have come to me. You should have told me. You chose not to, and now I'm getting fined by the city. That's your responsibility.
And isn't that just because we don't have a rental contract? These were, a property of my dad's, and it was just a very, like loose type of relationship. And, because we had told them nicely that, we were thinking of selling and we wanted to help them, then they've just become, really mean and looking to be kind of vengeful with us.
Right. Well, again, you can sue them in small claims court with or without a rental agreement for any additional costs that they cost you. At least that'll at least give them a little bit of a pushback. You also can raise the rent once again. Nothing prevents you. It's a single family residence. You can raise the rent as much as you like whenever you like. You might want to go to a website, which I've always talked about, called Rent-O-Meter. That's R-E-N-T, the letter O, meter, METER.com. And you can pop in your address and what kind of a property and how many bedrooms, etc. And it'll tell you what the market is. And I would certainly hit the high part of whatever that website tells you to do. And with that,
I did look at that. It doesn't allow for the commercial aspect. But Dennis, when are you back? Because I may need a consultation with you.
I'm going to be back on the 15th, but don't hit me on the 15th. I can tell you that. I think we arrive on the 14th at 11 p.m. So it'll be hit or miss whether I may get back to the office or not. But I've had a good trip, and we had to buy another suitcase, unfortunately. And with that, I'm going to say goodbye to you, young lady. And Dee Lucia, I'm going to ask you to unmute yourself. Dee Lucia.
Hi, Dennis. How's it going? Thanks for taking the call while on vacation.
It's kind of fun.
I actually have a question that's more related to your previous topic on the 3rd, and it's regarding an unpermitted unit. It's actually in, I looked it up online. It's Incorporated Southgate.
Okay, so it's the city of Southgate.
Okay, so I also have a tenant from hell, and more recently I've had a lot of issues with them for quite some time, but more recently they've started to get really aggressive and just terrible relationship that we have. And then they just blurted out, you know what, we're not going to play rent anymore. This was back early June. So and then they accused me of, or they let me know that there was mold in the unit. So I immediately hired a mold restoration company. I had them do a visual test. I had them come do a test. They confirmed mold in one of the bedroom closets and in the restroom. So trying to be a good landlord, I offered them an immediate relocation assistance. And I was offering them 3 months worth of rent because I wanted to get rid of the headache. So I wanted them to get out. They denied that. So so they denied that. They actually asked to stay till end of August. And if I were to, and then they asked for 2 months worth of rent because they haven't paid rent since June. So I now realize that I probably need to address the mold. And so I'm thinking of asking them if I can go in and make repairs, but my gut tells me they're gonna say no. So how do I go
Well,
about?
first of all, you need to immediately address the mold situation. Okay.
Right, yeah.
If a tenant says you have mold, you're just waiting for a lawsuit to happen. They're going to claim they have injuries and all this other stuff. So notwithstanding the fact that this is an illegal unit, you must take care of the mold. So I would get off the phone right now, get off this broadcast and find yourself a mold remediation. If you go to the Apartment Owners Association magazine, I don't have a referral, but they have a bunch in there. And they're usually pretty good vendors. Get somebody in there and remediate this immediately. That's issue one. Issue two is you're in a wonderful situation, believe it or not, because you're in Southgate, which is an incorporated city, which means that how many units on the property?
It's 2 rental units and then a single family home and then the unpermitted unit.
Okay, so with regard to the unpermitted one, you're under AB 1482 statewide rent control. All we got to do is serve on your tenants, and I presume they've been there longer than 1 year, a 60-day notice of vacate and give them relocation money, which is 1 month's rent. The tenant has no obligation to pay you any further rent. So here's your marching orders, young lady, and that is get yourself that remediated immediately. And then you might want to call our office and we'll issue them a 60-day notice to get out in accordance with the laws dealing with an illegal unit. You're going to need to, as you're getting the place remediated, you want to call the building and safety for the city of Southgate, get yourself turned in. You want to get what they call an order to comply. And then with that order to comply, we can then serve on your tenant a 60-day notice, pay them the relocation, your problem is solved. In addition, it is not that difficult to get that unpermitted unit into being a permitted unit under state law. So you're going to get yourself a contractor thereafter and make it legal. But right now, get it remediated immediately, get yourself turned into the city. And then once you get that order to comply from the city of Southgate, then we can do an eviction based on the illegal unit.
I actually kind of did some of the steps that you mentioned. I've talked to the city already. I've talked to code enforcement. I can permit this unit. There's no issue there. So I just, my next question was, can I go ahead and start or apply for the permitting? Can I move forward with that while I'm dealing with, because I've also already given them an eviction notice. I'm waiting for them to
Well, your
respond.
eviction notice is probably not good. You're going to need to get that order to comply first from the city where they say something that this is not a permitted unit and they're ordering you to take care of the situation.
So I should go to the city and get that order to comply.
Yep, turn yourself in, young lady.
Okay. And my last question is they're making threats that I will have to pay back any of the rent that they've paid while they've been there, and they've been there for
we've seen this
2 years.
before, and that the fact that it's an illegal unit that they want all their rents back, but there's nothing in law that states that you have to give all the rents that they have previously paid. It does state that they have no obligation to pay you future rent. So I don't see that as an issue. With that, I am going to move on to Ashok Madden. Say hello.
Yes, can you hear me?
I can.
Okay. Last week you I couldn't unmute in timely, and anyway. So we have a unit in Long Beach. A tenant has moved in her unit. She's been complaining about, and we're like I said, we try to jump on it and try to get it remediated. But she's been actually trying to get money from us, a large sum, to move out. She said, well, barely minimum I have to have 31,000. Rent is $850 below market. And we were saying that we will give you temporary relocation and we will remediate. So we got the remediation testing done, and we got the report and everything, and we are hiring remediation company to remediate. And she's moving. She keeps saying I'll move to temporarily, but she hasn't done anything. She has.
But whether she moves temporarily or not, that's not your problem. Your problem is to get the job done. So you're going to serve her with a notice that you're going to be going in maybe next Tuesday at 9 o'clock, and that the work is going to take 3 days. Whether she's there or she's not there, you're going to start the work. Simple as that. You might want to say, I'll also, just to show good faith, even though you have no legal responsibility to do this, you might want to tell her, I'm also going to put you up in a hotel for this 3 to 4 day period. And you pick the hotel that's close to your home or close to her home. And hopefully it's not a Four Seasons or a Ritz.
Yeah, she didn't, she said, oh, I have 3 kids and we need 2-3 rooms or some. So it is, we're negotiating. But what I was going to ask,
I mean, you only have to do this in good faith. There's no obligation, but you're going to tell them that you're going in next Tuesday at 9 o'clock. Give her a specific time and date and say, I'm willing to allow an allowance for your hotel of this amount. Do whatever the hell you want with it.
Okay, I got that. But the question now is, when the remediation people, when they say, hey, we need to change a bunch of windows and there's a lot more work. So then I talked to Fair Housing Foundation, and they say you can give a 60-day notice and $4,500, and you can have them move out because it's going to take longer to fix the place.
What city is this?
Long Beach.
Okay, well, Long Beach follows AB 1482. I think what the person at Fair Housing was trying to tell you is that if you're going to do major remodeling, then you can serve them with a 60-day notice and pay them relocation money, which is really only 1 month's rent. I don't know where they got the 4,500, but I wouldn't go that route. I would just get the work done, and because I'm not sure whether this is going to constitute major renovation where you're just changing windows and doing mold remediation. So on that basis, go ahead.
From pictures, there's a lot more work to be done. It could take 30 days. And he was talking about code section 1946.2, state code section.
Right, but this goes under the Long Beach statute. Actually, as I think about it, though, the Long Beach statute does have higher relocation costs, but it's really not under statewide rent control. You'd have to check the Long Beach code on that. But again, if you are going to do major renovation, you are going to need to have a contractor give you what they call the scope of the work, or something in writing telling you exactly what's work is going to be done, how long it's going to take. That's going to take longer than 30 days. And that type of work requires a building permit. You're also going to have to secure the building permit. But again, you really want to get this work done as soon as possible. So, but that is another route to go, to do substantial renovation and then evict them based on the Long Beach statute. But again, I'm not sure what the relocation is for Long Beach in that. Okay. Anyway, we are going to move on to Amarino. I'm going to ask you to unmute yourself.
Hello, Dennis.
Hello.
Taking my call. And first question is, so I'm trying to figure out where does someone go in order to figure out how to increase rents according to the area that the properties are at?
Well, you got to tell me what areas are your property at? I can tell you.
Okay, sure. So one is in the city of San Bernardino and the other one is in the city of Long Beach.
Okay, so let's first take San Bernardino. Is this a single family home or is it an apartment?
5 units. 5 units.
5 units?
Yes.
Okay, so in San Bernardino, assuming the property was built more than 15 years ago, you're under statewide rent control. Let me see if I've got the chart right here someplace. If I can find it real quick, and it's like 9.1. Let me see what it is. LA. They put it right here someplace for me. Here it is. I think I got it here. Pulling it up. Okay, so for San Bernardino, if I had eyes, I could see this. It is 9.3% for San Bernardino that you're allowed to raise the rent. What about the other property you said was in
Long Beach? Yes,
And is this an apartment or a house?
4 units.
4 units. So you're under basically the statewide, which is 8.9%. That's assuming you haven't raised the rent in both of these jurisdictions in the last 1 year period. So 8.9% for Los Angeles and Orange County, and for San Bernardino, 9.6.
Gotcha. And for future reference, where does one go to get this information?
Actually, I misspoke. For San Bernardino, it's 9.3%. 9.3% for San Bernardino. This is for properties after August 1st, 2024. And it is 8.9%. It works on the basis of the state law, which says 5% plus the CPI as published, as determined in April of each year, and then as published in August in the next few months thereafter. So as of August 1st, the CPI for San Bernardino was 4.3%. So you add that to the 5 and you get a total of 9.3%. Same thing is true for LA County. It was 3.9%. So the total is 8.9 if you add the 5% to that.
Okay, but where specifically does one find out these CPI rates?
It's under the Housing and Urban Development. Just look up Consumer Price Index.
Just Consumer Price Index. Okay, gotcha. And then my second question.
I should put this graph on my website, which I think I will do when I come back.
Okay, great. Yeah. All right. And second question is, say for example, you have a tenant that is constantly not paying you on time or partial payments, and I just want to put my foot down and I want to tell them, if you're going to continue paying in partial payments, I will not allow that. And if you can't pay the full rent, that I am going to evict you. I had this issue where I'm allowing the tenant to pay through Zelle and through a bank account. If they make a partial payment through Zelle still, or make a deposit, can I just return that and that's not considered a payment?
It's not considered an accepted payment because you had nothing to do with it. They just forced it into your account. So again, once that money clears, if you can Zelle it back, great. If not, then you use your own personal check, send it back to them, telling them that you've made an unauthorized deposit into my account, and then I would serve a 3-day notice for the full amount of rent.
Okay, great. Okay. And then I guess the last question is, you were talking about an illegal unit. I'm dealing with one right now for my friend's property. They're renting it a portion of the house illegally. And you were talking about not having to pay previous amounts of rent that they've already made. So I'm wondering, does that also apply to the city of Pasadena?
I think it applies everywhere. There's nothing in any statute that says you have to, but you'll find these attorneys that'll be suing for it. We've just got a lawsuit on that, and we're going to have to school them on that issue.
Gotcha.
And with that, young sir, I'm going to say hello to Austin. Austin, how are you, sir?
Good, Dennis. Thanks for doing this again while on vacation.
At
For
2
us.
o'clock in the morning, I might add, but
Yeah. Yeah. All right. Well, so I bought this fourplex in the city of Long Beach, and I bought it from a government-sponsored enterprise, a Fannie Mae loan. And I'm finding out that this type of loan is covered under the CARES Act. So I realized this after I already served the tenant a 3-day notice to pay rent or move out. So my understanding is I need to serve them a new notice and indicate in this new notice, please disregard the 3-day notice to pay rent or move out. You now have 30 days, not including weekends and judicial holidays, to pay rent.
No, that's not true. Okay, so number one, if your property is either has a Section 8 tenant or it has a federal loan, then you're under the CARES Act. And if you are under the CARES Act, if you're serving a notice to pay rent or quit, it has to be a 3-day notice to pay or 30-day notice to quit. And the 3 days are excluding Saturdays, Sundays, and legal holidays. And there's actually something in the code which we're shocked at that says that if you've got one tenant in your 8-unit building that's Section 8, then technically you have to serve a 3-day notice to pay or a 30-day notice to quit for every other tenant, even those that aren't under Section 8. So we're coming to grips with that crazy rule under the federal government, which is another reason either not to take a federal loan or never to take a Section 8 tenant if you have the ability to do it.
Yeah, I guess what I'm worried about is my realtor sent me a document put out by the California Association of Realtors. And when they talk about properties that are subject to the CARES Act, they explicitly say government sponsored enterprises such as Fannie Mae and Freddie Mac.
Absolutely.
Right. So this loan, the loan that I have is a Fannie Mae loan. And that, to me, my understanding is that is covered underneath the CARES Act.
Absolutely. Yeah, it's a federal loan. So you're going to need to, I mean, who knows whether the other side's going to figure this out, that you have a federal loan on it. It's not the easiest thing for people to figure out. So you might want, I don't know how far you are in this lawsuit, but you might want to just continue to see where it goes. But technically you're supposed to serve a 3-day notice to pay or a 30-day notice to quit.
Yeah, well, that was my follow-on question. How is the judge, how do they verify, or do they even go about verifying what kind of loan?
The judge doesn't do anything like this. It would be up to the other side to prove that you have a federal backed loan. And so I think depending on how far you are in the lawsuit, I probably would just continue on with it, because for the chances of you getting quote caught is probably slim, but there are some smart attorneys out there. And with that, I am going to move on, and I'm going to take somebody who I think I know who this person is. I'm going to ask P. Harris to unmute yourself.
Hi, you already called on me before.
Oh,
so I don't want to take.
You had your hand raised, young lady, so I'm going to move
I know,
on
I had
then.
another question because I was looking for the law that states what we can offer them for their daily per diem.
Well, I mean, that just states that it's just common contract law that for the time that they can't be in your unit for that daily period, that you're not going to charge them rent. It's as simple as that. Okay, we are going to move on to the Villegas family. I'm going to ask you to unmute yourself.
Yes, thank you so much for taking my call. I have a tenant in the city of Inglewood that moved out on the 28th of last month. In order for them to receive the full deposit, they went ahead without my consent or written consent to paint over the stains and the dark spots. When I came in and I saw everything they had done, of course, the discoloration on the walls was very visible, and also the droplets of the paints on the floors and the stains on the ceilings. So I hired a painter to come in, and he said it was really going to be hard to just let it go because it was very obvious. So I was charged $500 to repaint all the spottings and to remove the droplets on the floors and redo the ceilings for the stains. So now that I'm doing the itemization form, I'm wondering, can I charge them the full $500 for doing that?
Well, of course, because whatever it took you to return the premises back to its original condition, obviously this is considered unusual wear and tear, what they did, and obviously it cost you. So include the receipt for the $500, and that would be something properly that you could deduct from your security deposit. Anyway,
Okay.
go ahead.
And also because they gave me a 30 days notice on the 28th of July and they moved out on August the 28th, they're asking me to return the 2 days remaining for the rent because they moved out on the 28th. Am I supposed to return that per diem?
If they gave you a 30-day notice and then they paid for the entire month of August, is that what you're saying?
Yes, sir.
Yeah, then if they moved out in 30 days, then that's all you can get for that full 30 days worth of rent.
Okay, thank you.
All right, we're going to take one more call. I'm going to go with Sosi, and then let's think about this. It's 2 o'clock in the morning. I got to go to bed. So one more call, Sosi. I'm going to ask you to unmute yourself. Sosi.
Yes, thank you for giving us an advantage to ask a question. I'm here with Hagop. We have a property in Montebello. It's a townhouse. And the tenant has been delaying the rent payment for the last few months. And this month they have not paid the rent. What are the options for us?
Well, that's very simple. What city?
Montebello, California.
Okay, so Montebello, so if they don't pay the rent, you're going to serve a 3-day notice to pay rent or quit. And if they don't pay within the 3 days, then we can bring forth an eviction to have them excised from your properties. That's a pretty standard eviction.
Okay, Hagop has a question.
Hello, Dennis. Would you be serving the 3-day notice, or should we do it? I mean,
I actually recommend that we serve the 3-day notice because generally either it's not filled out correctly or it's not served correctly. And this way it's served by a registered process server if you use our firm, which will also take a picture of it. So I think it's kind of foolproof to do it that way. And in any event, thank you very much. Hey, ladies and gentlemen, this will be my last broadcast, at least on the road. So next time you'll get to see me at my home office, but I do appreciate everybody coming in. And what can I say? Arrivederci, or whatever they use in this area of the world. So anyway, take care, everybody. Have a great weekend.